ear, give attention, and you shall be heard. God save the United States, the state of Tennessee, and this honorable court. Criminal Court Judge Sandra Donaghy, Chancellor Casey Culbreth, and Chancellor Patricia Head Moskal presiding.
Thank you. Good afternoon and welcome to Davidson County Chancery Court Part 1. We are here for a hearing in a three-judge panel case. I'm Chancellor Pat Moskal, serving the 20th Judicial District in Davidson County. Joining me on the panel are Judge Sandra Donaghy, serving the 10th Judicial District and representing the Eastern Division of Tennessee, Chancellor Casey Culbreth, serving the 25th Judicial District and representing the Western Division of Tennessee. Today is September 25th, 2025. The case called for hearing is Allison Phillips et al. Versus State of Tennessee et al. Case number 23-1196, Part 1. Before we proceed today, I just want to remind everyone once again that today's hearing is being live streamed at the ongoing request of the public and the media. And I do want to thank the Tennessee Administrative Office of the Courts for making arrangements to live stream our hearing on the 10 Courts YouTube channel, as well as setting up the Zoom hearing for the participants. And because the hearing is being live streamed, I want to remind everyone, including our panel judges, to be sure to speak into your microphones so that we have better audio quality for purposes of the live stream. I would now like to ask one attorney from each side to introduce yourself and also introduce the other attorneys who are present on the Zoom hearing today. For the plaintiff.
Good afternoon, Your Honor. Linda Goldstein of the Center for Reproductive Rights. For the plaintiffs, I'm joined today by my colleague, Nicholas Cabot, also of the Center for Reproductive Rights, and Scott Tift of the Barrett Johnston firm.
Thank you. And for the defendants.
Good afternoon, Your Honor. Jenna Adamson on behalf of state defendants and non-party state subpoena respondents. I'm joined by my colleagues, Stephen Griffin and Zachary Clark today. Mr. Clark has filed a motion for pro hoc vice admission to the court.
And I'm glad that you mentioned that because we do not have a proposed order, and I don't know if the plaintiffs have any opposition to that pro hoc vice admission. So just as a housekeeping matter, if there is no opposition from the plaintiffs, if you would check on that and then submit a proposed order.
Yes, Your Honor. My understanding is that the plaintiffs do not oppose the motion, and I believe we sent a proposed order to Mr. Williamson earlier today, just a few hours ago.
Thank you. Today's is not an document. Plaintiff's motion to compel discovery. First, hear from plaintiff's counsel for their opening argument, then from the defendants for their response, and finally we'll return to the plaintiffs for their reply. We are requesting that each side observe a 60-minute time limit on today's arguments, but don't feel obligated to use all 60 minutes if you don't need it. We have reviewed the motion, the response, but may not have reviewed all of the last-minute filings. We've reviewed everything that was filed as of Monday, which was the deadline that the court set. Again, because this is a three-judge panel, after argument is concluded, the court will take the plaintiff's motion under advisement to allow the three-judge panel an opportunity to confer, and we will then issue our ruling as soon as we're able to do so. Are there any preliminary matters for the panel to address from the plaintiffs?
Not from the plaintiffs, Your Honor.
Or from the defendants?
Not other than the motion for PHV admission, Your Honor.
All right, we are ready to proceed.
Thank you.
Ms. Goldstein, will you or Mr. Cabot or Mr. Tift be presenting argument?
I will be presenting argument today, Your Honor.
All right, thank you very much. You may proceed.
Thank you, Your Honor. May it please the court. Nearly a year ago, this court denied the state's motion to dismiss the claims against it on the ground that it was immune from suit, meaning that the state was subject to the basic rules of discovery, such as conducting reasonable searches for responsive documents and preparing privilege logs. Nonetheless, the state has not complied with its obligations. It was not until we received the opposition to our motion on Monday that we learned that Governor Lee's office had not conducted any electronic searches of custodians' email accounts until 5 months after we served our subpoena. And only then those searches were conducted because we had provided a list of proposed search terms. And it was not until yesterday when we were served with one of the overdue documents, the belated Karsner Declaration, that we learned that the Tennessee General Assembly still has not conducted any searches for responsive documents. I will start by explaining why we need the documents that we have subpoenaed from the governor's office and the Tennessee General Assembly, and then go on to discuss why they should be required to provide privilege logs, and then why the state has not adequately demonstrated that the requests are unduly burdensome. I will finish by discussing our request for a 300206 deposition of the state and for up-to-date maternal mortality and morbidity statistics from the Department of Health. In ruling upon plaintiff's motion for a preliminary injunction, this court held that plaintiff's constitutional right to life claim is subject to strict scrutiny review. This means that the burden is on the state to show that the abortion law is narrowly tailored to serve a compelling state interest. The same strict scrutiny standard should apply to plaintiff's vagueness claim. A strict scrutiny analysis means more than just after the fact hypothesizing about what the state's interests might have been in enacting the statute. For example, the state has asserted in its papers that the abortion ban and its medical necessity exception are needed to protect maternal health and safety and the integrity of the medical profession. Plaintiffs should be allowed to test those assertions by examining what evidence was before the lawmakers on those subjects. The discovery we are seeking could also be probative on the core issue of whether the language of the medical necessity exception is ambiguous, as Senator Biggs admitted in the public legislative record. Without this kind of discovery, plaintiffs are stuck with a record of the state's own choosing on its interest in enacting the abortion bill. Plaintiffs have no way to test the truth of what the defendants are asserting about the bases for the state's asserted interests without seeing the documents. The state has asserted in its motion papers and in its objections that legislative and deliberative process privileges are absolute shields from discovery. That is not correct. Legislative privilege is a qualified privilege that requires the court to balance several factors, including the public need for full development of the relevant facts and the threat of chilling legislative duties. That balancing test is what the court did in the Nashville Student Organizing Committee case cited in our papers. That case went so far as to allow Tennessee state legislators to be deposed, a far greater imposition on public servants than the documents that we are seeking here. There is no question that when it is time for this court to perform that balancing test, that this case implicates matters of great public interest. It raises a serious constitutional issue, the right to life of pregnant women with high risk or complicated pregnancies. The panel has held at least for purposes of the temporary injunction, that plaintiffs have a likelihood of success on their constitutional claims. For these reasons, this case is distinguishable from the Hubbard case, which defendants cite, where the court conducted a balancing test and found that the legislative privilege did shield legislators from discovery, where plaintiffs had alleged only a facially invalid First Amendment claim, and plaintiffs also sought the discovery in order to prove the legislators' motivations in voting for a bill, which is not a proper basis for discovery from the legislature. Apart from the fact that legislative privilege is only a qualified privilege that can be overcome on a sufficient showing of need, it does not ordinarily apply to all communications between the legislative and executive branches, or to communications between legislators and outsiders, such as lobbyists and special interest groups. The communications between the governor's office and legislators, which we attach to our supplemental filing, which were produced in response to a public records request, belie the state's claim that such documents are always subject to a legislative privilege. And the cases cited in the state's papers do not support their broad claims either. In the La Union 2 case, the plaintiffs had taken the deposition of the chair of the Ballot Security Committee of the Harris County Republican Party in a case challenging voter registration laws. The party official was permitted to testify at length about his communications with Texas state lawmakers. The only communications as to which the legislators asserted privilege, and the only communications which were at issue on that appeal, were communications in which the party official was responding to a specific legislative inquiry, which the court held made those communications a legislative function. Essentially, he was deputized as part of the legislature, which is not ordinarily the case for lobbyists or special interest groups. Similarly, the deliberative process privilege is also a qualified privilege and can be overcome when there is sufficient need. The Tennessee Court of Appeals has ruled that the deliberative process privilege must be applied cautiously because of Tennessee's strong public policy, which favors government transparency. They noted that if the deliberative process privilege were applied broadly, it would essentially swallow up all of the provisions favoring transparency in government. And apart from the fact that it is a qualified privilege, deliberative process privilege does not apply at all to purely factual material or to communications with people outside of the governmental body at issue. One of the key factors I want to underscore here is that our motion does not require this court to make any ruling at this point as to whether any particular document or even any particular category of documents is protected by the legislative or deliberative process privileges. Those disputes can best be presented to the court after we get privilege logs, which identify the documents for which the privilege is asserted. In that way, we can identify the specific documents that we think are subject to the production, and the court can appropriately balance the significance of the documents for the trial of this case. In fact, many of the cases cited in the state's papers, such as the Citizens Union case and the La Union 1 case, involved disputes that were resolved based on privilege logs prepared by the government officials. The exceptions where there are no logs are cases like Hubbard or Purnell, where the legislators, unlike the governor and the Tennessee General Assembly here, raised the issue by moving to quash the subpoenas directed to them, an avenue that the governor and the Tennessee General Assembly chose not to pursue here. We have already offered that we would allow the governor and the Tennessee General Assembly to prepare categorical logs, which would allow them to group communications between the same people on the same subject matter into categories to avoid the burden of itemizing every single responsive communication. But counsel have rejected that offer without explanation. The state relies on the Purnell case to assert that they do not have to produce any log, but that case is readily distinguishable because the document request there, again, improperly sought documents regarding legislators' motivations, which we are not seeking. So preparing a log there would not have identified any documents that could be subject to production. The governor and the Tennessee General Assembly should be compelled to review their files for responsive documents and to log anything for which they assert privilege. I acknowledge now that the supplemental response that we filed on Monday asked for a blanket waiver based on the complete failure to produce any kind of privilege log. And in fact, we believe that the state's conduct here, in which they went through the motions of a meet and confer, continually assuring us that the governor was preparing a privilege log, only to finally turn around on August 15 and tell us that the governor, as well as the Tennessee General Assembly, were standing on all of their objections. That conduct is, in our view, egregious enough to justify that sanction. Nonetheless, in the interest of having this case tried on the merits and on the facts, we believe that the more appropriate course would be to require the governor and the Tennessee General Assembly to produce logs so that we can test their privilege assertions and the court can make reasoned decisions on the scope of the legislative and deliberative process privileges. I will turn now to the state's burdensomeness argument. And I should say here, I am referring to the subpoenas to the governor and to the General Assembly as discovery requests directed to the state because that is what the state directed us to do. When we served a document request, which we initially served in December of last year, the state of Tennessee objected and said it could not produce any documents because it didn't know where to search. It didn't have custody of all of the documents. So we were directed essentially to serve subpoenas on the relevant government documents that would have the relevant government departments and agencies and officials that would have the documents we were looking for. And so we served those subpoenas upon the governor and upon the Tennessee General Assembly and its various committees, essentially as agents of the state, as the state directed us to do in its objections. Turning now to the burdens that the Tennessee General Assembly and Governor Lee are asserting. Tennessee General Assembly submitted a declaration. They submitted it yesterday after it was due, which only hypothesizes that the Assembly could have a lot of documents to review. They can't say with any certainty that they do have a lot of documents to review because they have not run any preliminary searches across any custodians. So they do not know. It's pure speculation that searching for documents would impose a burden on the Tennessee General Assembly. Rule 26021 plainly requires the party who is opposing a discovery request on the grounds of burden to show the burden. And the Tennessee General Assembly.
Excuse me for interrupting. I just want to get clarity. If you're talking about the Tennessee General Assembly or the governor, aren't we proceeding under Rule 45 based on the subpoenas that you have served rather than Rule 26? So I just want to make sure I understand your arguments.
Well, it's formally, it is governed by Rule 45. That is correct. But our view is we could have sought this discovery by moving to compel the original document request that we served upon the state of Tennessee. And we simply served the subpoenas as directed by the state on the governor and the Tennessee General Assembly, because it was the state's position that basically no party document request could be served on the state of Tennessee. And so the Rule 45 request essentially serves as a party request. We don't think that there's
except that a Rule 45 subpoena is not a party request.
it is not a party request, but we merely did that because frankly we did not want to burden the court with what we viewed as a purely formalistic dispute at the commencement of discovery.
Well, I appreciate your position, that you view it as a formalistic request, but they have been issued, they were objected to, and so in resolving what should be produced with regard to those, in response to those subpoenas, I'm just trying to see clarity, or that the court needs to review that under Rule 45, given the way that it's presented to us. If you also are making arguments under Rule 26 with regard to your requests for production directed to the state, we're happy to hear that as well. I just want to make sure that the path that we're proceeding down is the correct one.
Understood, Your Honor. And I believe that even under Rule 45, a witness objecting to a subpoena on the grounds of burdens has the onus of establishing the burden, and the point here is a straightforward one, that onus has not been met here. Going back to Governor Lee, the argument made to support Governor Lee's claim of burden is that the first search, which was not made until late August, 5 months after the subpoena was served, and 8 months after the original document request was served, we're told that search generated a large number of documents. But that is not the appropriate gauge. The first search in electronic discovery almost always generates an excessive number of hits. The ordinary process in electronic discovery is to run the search terms to gather documents that are then deduplicated, so that one email sent to 12 different people doesn't have to be reviewed 12 separate times. And after they're deduplicated, they are reviewed for responsiveness and privilege. If the search terms, the initial search terms, generate an exceptionally large number of hits, the ordinary course is that counsel reviews sample documents to determine whether the search terms are capturing large numbers of irrelevant documents. If so, the search terms can be modified. There are many ways of doing that, by adding proximity connectors, by eliminating certain search terms that are generating lots of irrelevant documents, so that a more manageable number of documents can be collected and subjected to attorney review. In the absence of any sign that the governor's office ever undertook these basic steps of electronic discovery to narrow the scope of the search, their assertion of burden, the numbers that they've given, are frankly conjectural. And I would also note that we have offered to work with the defendants to identify search terms. We've asked for we could modify them, and they have not agreed to do that, although that is standard practice. Um, and yes, I'm now looking at Rule 45. Rule 45081D imposes the same burden on a witness to prove burden that Rule 26 requires. So, on this point, there's no distinction. Governor Lee and the Tennessee General Assembly have to establish the burden, and our position is that neither of them have done that, and for that reason, the burdensomeness objections that both of those parties have asserted should be overruled. Turning now to our notice for a 300206 witness, I should start by saying that there is no dispute that the issues on which we are seeking a representative to testify are key issues that will be litigated at trial, such as the state's interests in enacting the medical necessity exception and its understanding of the key statutory terms, such as substantial and irreversible impairment of a major bodily function. There is simply no legal authority supporting the state's position that the state is not encompassed in the term government agency in 300206. Federal courts have held that the same term in Federal Rule of Civil Procedure 30B6, on which Tennessee Rule 300206 is modeled. Federal courts have held that that language applies even to foreign nations, and the U.S. government routinely designates representatives to serve as 30B6 witnesses, representatives in federal court. We've also presented examples where the state of Tennessee has designated representatives to testify on its behalf in a case before the Tennessee Claims Commission. So the argument that 300206 does not apply to the state has no support. So the state should be required, as any party to a lawsuit, to designate representatives to be deposed on the noticed subjects.
May I interrupt again?
Yes, absolutely.
This is Chancellor Moskal. On those two categories that you identified, and I just want to make sure I understand your position on the state's interests, what we have in this situation is a separate statutory provision that delineates the legislature's findings, including the interests of the states, at 3915-214. And so that statutory provision and its legislative history, is that the universe? I know this is not your position, but my question to you is, why is that not the universe of documents that the court is to consider on the state's interest issue? And then for with regard to the governor or the state's understanding of key statutory terms, once that is presented to the court and is being challenged, why is that not the court's question of law to determine what the meaning of those statutory terms are? And does it make any difference what the legislators or the governor thought those terms meant at the time of enactment? That was a long question, and I apologize. It has two parts.
Two
one
questions.
Is the state's interest, and one is the understanding of the key statutory terms.
Well, so far, we have asked the state to identify its interests, and we've been directed to the legislative history without any specific citations. We have asked the state, we've served interrogatories. We expect those interrogatory responses next week, in which we've asked the state to identify which portions of the legislative record do you intend to rely upon. So that is all we know at this point, and perhaps the state will point to the findings in 39-15-214. Perhaps they will point to other things. I do not know that at this point. My point on goes to really testing those. I mean, certainly to the extent the state asserts anything other than what's there, we're entitled to assess that. None of the interests in 214, for example, is specific to the medical necessity exception, and the state interests that we're exploring are not so much the state's interests in why have an abortion ban at all, which is, or why have abortion restrictions at all, which is what 214 focuses on. But what is the state interest in drafting a statutory provision that departs from the medical standard of care? And that's really the issue that we would need to probe, and that is not addressed in any of the legislative findings. And so we would like to have an understanding of what the legislature did or didn't do in terms of speaking to physicians, in terms of speaking to physician associations, in terms of speaking to advocates, to generate any kind of understanding of what the impact of restricting medically necessary care would be, what the impact of departing from the medical standard of care would be. So those are the issues that we would we would like to see evidence on. Maybe there is no evidence in the record on that, and that itself would be probative, because that would certainly undercut any claim that the interest was compelling, and it would undercut any claim that the specific wording of the medical necessity exception was narrowly tailored to achieve that interest.
Thank you.
And I must admit, Your Honor, I didn't write it down. I lost the second part of your question.
The second part was the legislature or the governors or whomever's, the state's understanding of the key statutory terms under Tennessee law. The construction of statutes is a question of law presented to the court. And there are a number of principles that can be applied as to whether the court is to look to just the plain language of the statute, or if the terms are ambiguous, there are statutory construction principles that then come to bear. And so if that's strictly a legal question for the court, help me understand why you need this discovery.
Yes, Your Honor. We don't need this discovery to establish what the meaning of the language is. What we need it for is to establish that ambiguity in the statute is a feature, not a bug. That it was ambiguous because it was ambiguity deterred providing medical care. And so showing that legislatures acknowledged the ambiguity of the statute is important for that argument.
Thank you.
So I had actually concluded what I was going to say about the 300206 witness. My final point was on the subpoena to the Department of Health, which has not produced the non-public maternal morbidity and mortality data that are within its possession, custody, or control. We've been directed to the publicly available data, which stops in 2022, and so does not capture the maternal mortality and morbidity data after the trigger ban first went into effect. We're not asking for draft reports. We're not asking for government analysis. It is our understanding that the Department of Health gathers this information. It has this information, so it should be produced to us. And that
did I misread in the papers that there was a portion of, maybe it was just morbidity data for a portion of 2024 into 2025, but not before 2024 and not for the second quarter of 2025.
I might have to look to Mr. Cabot for the specifics on that. My understanding is that what we did receive was unpublished data on intentional terminations of pregnancy. These are called ITOP reports. Right. ITOP reports are submitted by, they're required to be submitted by hospitals and clinics that provide abortions in Tennessee. And so we asked for that data, and we received a declaration from a Department of Health employee with summary statistics of the ITOP reports that have been submitted to Tennessee's Department of Health since the ban went into effect. Mr. Cabot has pointed out to me that perhaps what Your Honor is thinking of is the fact that the state has directed us to maternal mortality and morbidity statistics that were published in 2024. But although they were published in 2024, they covered an earlier time span.
Well, I've not seen, and the panel has not seen any of the documents that have been produced. So we're flying a little bit blind here, and we're relying on what was presented in the papers as to what has or has not been produced. Not that we're asking for all of those documents to be submitted, don't misunderstand, but that's why we're relying heavily on your briefing in support and in opposition to.
Understood, Your Honor, but it's as I said, it's my understanding that the only maternal mortality and morbidity data that we have access to is the publicly available data, and that stops at 2022, even though it was published later, and I think Your Honor is probably referring to some of the email correspondence that was attached, which addressed this back and forth on this issue.
I will ask the state's attorneys the same question. So we'll see if we can clear that up. All right, thank you. So it's your position that you've not received any non-public mortality and morbidity information after 2022. You've only received the published reports.
Correct, Your Honor.
Okay, thank you. I didn't mean, go ahead. Is there, what
No,
else would you?
that was it, Your Honor. So in sum, we're asking that the Tennessee General Assembly and Governor Lee be directed to conduct reasonable searches, produce responsive, non-privileged documents, provide us with a log, categorical if necessary, of withheld documents, that the state produce a 300206 witness to address the issues identified in our notice of deposition, and that the Department of Health produce the maternal mortality and morbidity information from 2020, from 2023 to the present.
And just to make sure that we've covered all of the categories in your motion to compel, what is your position? And I'm looking at the actual motion. The first item is that the defendants conduct a reasonable search, and you focused on the governor and the General Assembly. Are there any of the named defendants that you are pursuing your motion to compel, such as the Tennessee Board of Medical Examiners, the Tennessee Board of Osteopathic Examination, or the Attorney General?
At this point, we've deposed the Board of Medical Examiners and the Board of Osteopathic Examination, and I don't believe we're seeking anything further from them. We had been seeking the same, I guess, the state interest documents from the Attorney General and the individual defendants. It's our understanding that none of those sources would really be fruitful. So we're not asking that they run new searches for state interest documents. Our focus really is on the governor's office and the Tennessee General Assembly for those documents.
So are you withdrawing that portion of your motion to compel then? I'm trying to narrow down and pinpoint exactly what issues are in front of the panel that are remaining issues that we still need to resolve.
Yes, I think we can take those off the table, Your Honor.
Okay, so your subcategory 1, all defendants conduct a reasonable search for and produce documents related to the state of Tennessee's interest in enforcing the amended abortion ban and the medical necessity exception. You are withdrawing that as to the named defendants. Does that include the state of Tennessee, or is it with that exception of the state of Tennessee as is now being pursued via the subpoenas?
Correct. It's with the exception of the state of Tennessee, Your Honor.
So that the governor and the legislature.
Correct.
And just for clarity, for everyone's benefit, you have used the term amended abortion ban with capital letters in your motion to compel and in your discovery request. But for clarity, that is defined in your instructions as the 2023 version of the criminal abortion statute that includes the medical necessity exception. We are not talking about the 2025 amendment, correct?
I believe that our definition encompasses future amendments. So yes, it would include. I mean, our subpoena was served before there was an amendment.
Your subpoena and your discovery request.
Correct. But we I believe that the definitions were worded broadly enough so that they would encompass subsequent amendments as well. We obviously couldn't refer to amendments that didn't exist at the time.
Well, let's look at what your definition is, because I want to be very clear about that for purposes of this motion. If we could take just a moment here.
Yes, Your Honor.
And I'm looking at the your exhibit A to your declaration, which is plaintiff's first set of requests for production of documents to defendants. At paragraph 10, amended abortion ban shall mean the current version of Tennessee Code Annotated 3915-213 as amended by House Bill 883, 2023 legislative regular session.
That
So I'm reading that as defining amended abortion ban as the 2023 version of the statute 3915-213.
I'm just checking to see. Yes, that's what it says there. I must say that it appears from his privilege log that the Attorney General understood this request to encompass the 2025 amendment, because there are items on their privilege log that relate to the 2025 amendment. So I think it's fair to say that the parties understood this to request documents.
Well, it's hard for the court to rule on what the parties understood if we don't know what the parties understood. And that's why I was relying on your defined term. And I also looked at the subpoena addressed to the Department of Health by way of example. I did not compare all of them to see if it was defined the same way. But the amended abortion ban is defined identically to your request for production. And again, we've not seen the privilege logs yet, so we don't know what the parties understood it to mean.
Well, yeah, we could certainly amend the request, Your Honor.
I'm not asking or suggesting. We have one set of requests for production of documents in front of us that were served way back in
December.
December of last year. Thank you. And so that is the subject of the motion to compel today that we're hearing today. What you all do going forward as to serving supplemental requests or whatever, we'll put a pin in that and reserve that for another day. I'm just trying to pinpoint what is in front of the panel that is necessary for us to decide so that the parties can move forward on this set of discovery.
Understood. Thank you, Your Honor. So
right.
Yes.
And I will ask the defendants the same thing, because I just want to make sure we're all on the same page on that. So that's request number one. Number two, that all defendants conduct a reasonable search for and produce responsive documents. That is a more generic request, not related to the state's interest as I understand your meaning. But if I'm incorrect about that, please help me out here, which would be your request for production. They were identified as 5, 6, 7, 8, 10, and 11. Your state interests requests are 15 through 18. And I understood that this second category of documents then are those remaining requests.
If I'm sorry, Your Honor, I'm a little bit behind you because I don't have the notice in front of me, which I apologize for.
Oh, that's perfectly all right. And if you want to make a note of that and help clear us up on rebuttal, you're certainly welcome to do that. And I was pulling that from your memorandum in support of your motion to compel in your introductory, the factual background, plaintiff's document request to defendants was
Yeah.
where I had pulled those request number because I wanted to be specific about that. You identified requests 5 through 7, 8, 10, and 11. I understood those to be your more general requests, and then specifically with regard to the state's interest requests, those were number 15 through 18. So if you could help confirm that.
Yes, Your Honor, you're correct. You're reading it correctly.
Okay. All right, that's helpful. And then number 3, all defendants produce privilege logs in compliance with Rule 26.025. And you have a privilege log from the Department of Health and from the Attorney General. Is that correct?
That's correct, Your Honor.
And you've got a privilege log, and I can't remember which one, from one of the boards, but not the other because they said they did not withhold any privilege documents. Is that correct?
That's correct, Your Honor.
And so that just leaves the general privilege log by the state, which you're identifying as the governor and the Tennessee legislature.
Correct, Your Honor.
Okay. And you did get one from the AG. Did I say that? I think I did.
Yes, we have, Your Honor.
Okay. All right. And then category number 4.
Yes.
Is all of the third-party subpoena requests that you're pursuing, and specifically with regard to Governor Lee and the General Assembly. What is your position with regard to the House subcommittees?
It's the same, Your Honor.
You're
objections,
including all of those.
Yes, Your Honor. The objections were served on behalf of the General Assembly and the 2 subcommittees jointly. They're essentially the same requests and the same objections, and we would press all of them.
Okay, I just wanted to clarify, and that's helpful. And in your motion, you say, including with respect to the state of Tennessee's interest in enforcing the amended abortion ban and the medical necessity exception. And I looked at the items, the subpoena ducis tecum items to be provided, and I did not see that request regarding the state's interests. And I wondered, you were including that in one of the categories, and could you help me identify that?
I don't believe we had the same state interest requests as 15 to 18 from the document requests in those subpoenas. But
I didn't find them.
Yeah, but we essentially have our requests for all documents and communications related to the medical necessity exception and the various communications. Basically, that's what we are pressing, and we believe that those documents, would encompass any communications that go to the state interests that the state would have to prove at trial.
So you're lumping, even though you separated them out and spelled them out differently in your request for production of documents, you did not do so with your subpoena, but you're treating your subpoena request for documents as including that, although not specifically identifying. Did I restate your position?
Well, I
I'm putting
suppose
words in your mouth.
you,
So go ahead.
I suppose one could say that the state interest requests, document requests are more in the nature of contention type requests. And our view is that if we were to get the categories of communications called for in the subpoena, we would get the documents that relate to the state interest without requiring the document reviewers to identify, does this document relate to a state interest or not?
All right, thank you. On category 5, that the department produced data on induced terminations of pregnancy since August 25, 2022. And that's incomplete is your position.
No, the ITOPS, the induced terminations of pregnancies, that we have received.
Okay. So that issue is resolved.
Yes.
And then the last one.
Well,
you've
that
already-
issue is just the ITOPS, not the other items in
the mortality and morbidity.
Correct.
I understand. And then on item number 6, category number 6, that's the Rule 3002 state designee, or probably more accurately, designees plural.
Yes, Your Honor, that we're still pressing.
All right, I think I have a better handle on exactly what's remaining based on your motion to compel. Thank you.
Thank you, Your Honor.
And you'll have an opportunity to reply to the state's argument.
Thank you.
Okay. I mean, turn to the state then, and we're right at an hour. We're on target here. I'll turn the argument over to the state defendants.
Thank you, Your Honor. This is Jenna Adamson. With the court's leave, we were planning to split argument. I am a little confused, even if Your Honor has clarified for your own purposes what plaintiffs are still pursuing. Have they given up the argument about defendants' reasonable searches?
Well, my understanding is that, are you talking about category number 2 on their motion to compel?
Exactly.
Which is what I'm using as my outline.
Okay.
As I understand it, they are with respect to the state defendant boards and attorney general, but not with respect to the state in general, which are then also governed by the Rule 45 subpoena.
Okay.
Directed to the governor and the legislative bodies.
Understood. Okay. So limiting the state to the General Assembly and the governor, they are otherwise giving up reasonable search arguments. Okay. So my colleague, Mr. Griffin, may fill in at the end. I think there may be a few issues that he will cover, but I will start with relevance, undue burden and cost, privilege, whether the state of Tennessee can be deposed, and very briefly, sovereign immunity. So to start, none of the information that plaintiffs are seeking in discovery is necessary to resolve defendants' pending motion for judgment on the pleadings. Granting that motion, even in part, would significantly narrow the scope of discovery. And I think Ms. Goldstein's admission today that the discovery requests seek information under the unamended 2023 statute underlines that. The state did produce and log documents after that date, subject to our objections based on mootness and other arguments, including vagueness.
Well, as you will recall, we did not stay discovery, and so that is ongoing. So
yes,
I'm not, I understand your position that you're not giving up any of those arguments, but we need to move on to the merits of the discovery request.
Yes, Your Honor. So setting that aside, there are three big overarching problems with plaintiff's state interest related requests, which seem to have been narrowed to the governor's office and the General Assembly. That's lack of relevance, disproportionality, and pursuit of privileged materials. I'll go through each of those. Under Rule 26.021 and West versus Schofield, plaintiffs cannot obtain irrelevant materials. Plaintiffs have finally explained why they want them in a little bit more detail. Plaintiffs say one of the reasons they want them is to know how to interpret the statute. I believe my friend on the other side walked that back a little bit, but if that is one of the reasons, as Chancellor Moskal pointed out, that interpretation of a statute is a question of law. So documents and communications related to how an individual legislator interpreted the statute would not be relevant. In addition, courts have repeatedly said that evidence about an individual legislator's opinion about how to interpret a statute is not good evidence of what the statute means. My friend on the other side also said that they would like the information so that they can test state interests. Respectfully, plaintiffs can test state interests with expert reports. That is often how state interests are tested in these cases. Courts routinely consult public sources alone in determining whether a statute passes constitutional muster under any standard of review. We cited cases applying rational basis, which of course we argue applies here, intermediate scrutiny, and strict scrutiny. To the extent plaintiffs' requests then seek non-public materials about legislative intent, that information is irrelevant, and any request for such information should be denied on relevance grounds. Moving on to undue burden and cost, Rule 26.
And by relevance grounds, let's just be clear, under 2602, it is not a basis for objection on the grounds of relevance if it is reasonably calculated to lead to the discovery of admissible evidence. So I often refer to that, just for ease, as the scope of discovery. It's not just a strict relevance standard. It incorporates that broader group of documents that can reasonably lead to the discovery of admissible evidence.
Understood, Your Honor. We don't think, though, that any non-public documents about legislative intent would be relevant, both because we think the issues here are questions of law and because courts don't consider those types of materials in constitutional challenges like this one. Moving on to undue burden and cost, Rule 26.021 also provides that a party need not provide discovery that is not reasonably accessible because of undue burden or cost. And we agree with your suggestion, Chancellor Moskal, that Rule 45.07 applies to the subpoenas to the governor and to the General Assembly. These are non-parties. Plaintiffs did not challenge our insistence that they send non-party subpoenas to the General Assembly and the governor's office, so Rule 45 does apply. So there are several reasons that these subpoenas are overly burdensome. To start, they are not proportional, even if they have even if the documents they request have some sort of minimal relevance, they are just not proportional to the needs of the case because plaintiffs have access to so many public documents that evidence the legislative interests and the legislative intent in this case. Chancellor Moskal, you pointed to Tennessee Code Annotated 3915-214. That makes 77 findings in support of regulating abortion in the way that the challenge statute does, including findings that are relevant to plaintiff-specific challenges, such as paragraph 23, there is evidence that an unborn child is capable of feeling pain as early as 12 to 15 weeks gestational age. Paragraph 43, abortions performed at any gestational age pose a risk to the mother. Abortion increases the risks of subsequent preterm birth and placenta previa, life-threatening hemorrhage, postpartum hemorrhage, and cesarean delivery. Paragraph 59, today the individualized nature of abortion creates a significant risk that prenatal screening tests and new technologies will be used to eliminate children with unwanted characteristics. Paragraph 60, there is substantial evidence that is already occurring. In the United States, the abortion rate for children with Down syndrome is 67%. In paragraph 69, the integrity and public respect of the medical profession are significantly harmed by physician involvement in practices that have been rejected by the international community, facilitate discrimination, or otherwise create a disdain for life. And paragraph 70 through 76 list all of the, or many of the legitimate, substantial, and compelling interests that support the statute challenged here, and that the state has offered in support of the statute challenged here. And the US Supreme Court made clear in Dobbs that courts should defer to such legislative findings in areas like abortion regulation that are fraught with medical and scientific uncertainties. And beyond the legislative findings, as my friend on the other side pointed out, there is legislative history. There are hours of video and audio related to the trigger law and subsequent amendments. Plaintiffs have access to all of that. And in light of their access to all of their public materials, plaintiffs simply haven't shown that failing to obtain additional non-public materials that my friend on the other side indicated may or may not exist, that's certainly not necessary for their case. And at the same time, the burden on the governor and the General Assembly to producing such documents is significant. And we detailed that burden at pages 11 to 16 of our opposition brief. But to highlight a few details here, the governor's office collected data from 10 custodians identified as having responsive information from the requested 6-year time period. The governor's office did a search when plaintiffs finally provided search terms and narrowed custodians. So my friend on the other side emphasized that it took us 5 months to run a search. Well, we objected in April based on privilege, undue burden, relevance, and other grounds. And plaintiffs waited until the end of August to suggest narrowed search terms and narrowed custodians. And even when the governor's office considered running those terms, it found that even just running those terms would be extremely burdensome and costly because of the amount of data collected from the custodians and the cost of simply uploading that data to run terms against. And searches can't be run until the data is uploaded. Plaintiffs' counsel might say that that's conjectural, but we received the data. We have an estimate of how much it would cost to host that data. Those aren't conjectural numbers. And even plaintiffs' narrowed requests to the General Assembly would result in a list of around 100 custodians. And so if you consider the fact that plaintiffs are trying to get the same type of information from the General Assembly that the governor's office collected, and the number of custodians is 10 times as large as the custodians from whom data was collected in the governor's office, it's not speculative to say that that will be extremely burdensome and costly just to host the data to run search terms against. And these burdens, especially for non-parties, would be improper on their own. But when you consider the tenuous relevance of the information sought, again, my friend on the other side today said she doesn't know, plaintiffs don't know if that information even exists. And the disproportionality, it's quite clear that that burden is an undue one. So the court can also deny plaintiffs discovery against the General Assembly and the governor on undue burden grounds. And we do think that that's a very strong ground, especially given the specific allegations in the governor's declaration, as well as the General Assembly's declaration.
And just again, for clarity, I want to make sure we're using the right terminology.
Yes.
Under the Tennessee Rules of Civil Procedure, it is spoken of in terms of undue burden or expense. Proportionality does not appear anywhere. That term, I think, is borrowed from the federal rules, but Tennessee has not adopted that proportionality standard. There are factors that are to be considered under the Tennessee rule, but in terms of a strict proportionality standard, that's not provided for, that I see.
Yes, so I have two responses to that. One is that, as plaintiffs have pointed out in their briefing, these rules, the rules that apply here are consistently interpreted consistently with the federal rules, even though they might have slightly different language. And then I would also point, Your Honor.
That can be the case. I'm sorry to interrupt. That can be the case, but where the rules utilize different language, and the federal rules were fairly recently amended to add that proportionality standard. Tennessee has not done so. So that's an important distinction.
Your Honor, there is in Rule 26.021 in the third paragraph.
I'm aware, and those are factors that are to be considered, and they may somewhat track based on the needs of the case, the amount in controversy, but it doesn't use that proportionality standard as imported from the federal rules. That's my only point. I just want to make sure we're applying the correct standard here.
Yes, Your Honor, I understand. There is a reference in Roman numeral 3 to the discovery is unduly burdensome or expensive, taking into account the needs of the case.
That's what I was just referring to.
Yes, so we think that that incorporates the proportionality standard.
That's debatable, I guess, but let's go ahead and move on. I just want to make sure we're using the language that is provided for under Rule 26.
Yes, Your Honor.
Please go ahead.
So moving on to privilege. Under Rule 26.021 and other Tennessee law, a party may not obtain privileged information in discovery. So that's our baseline. We are agreed with plaintiffs that the court doesn't need to address privilege, but for different reasons. Rule 26.025 applies to information otherwise discoverable. So there's no need to address the privilege claims if the court resolves the governor's and the General Assembly's objections in their favor. Other objections. There are several grounds for privilege here, but as my friend on the other side's argument suggests, I think legislative privilege is really at the heart of this dispute. Now, my friend on the other side said that legislative privilege is qualified. That's not correct. Legislative privilege as a matter of common law is or may be qualified, but we're talking about legislative privilege rooted in the Tennessee Constitution speech and debate clause. And Tennessee courts have consistently said that the legislative immunity provided by that clause is not qualified, but absolute and broad.
But that's immunity. That's immunity and not privilege. And are those terms coextensive in your view?
Yes, Your Honor, and there are at least two reasons for that. One is that Tennessee appellate courts, I think most helpfully in Mayhew, have said that because the Tennessee speech and debate clause is nearly identical to the US Constitution speech and debate clause, that Tennessee courts may interpret those clauses to have similar scope. Certainly, they may find federal precedent particularly persuasive, I believe is the language.
And Mayhew versus Wilder, though, was directed to the issue of immunity from suit,
Yes.
not from, not as an imposition of a privilege that shielded a legislator from producing documents.
Yes, Your Honor. We do think that the principle applies to privilege, though, the persuasiveness of federal precedent on this point, and federal courts uniformly treat legislative immunity and privilege as having the same scope, at least the legislative immunity and privilege that come from the US Constitution speech and debate clause. And we cited a DC Circuit case, which I think is helpful on this point, because it points out that the text of the clause doesn't actually refer to immunity from suit. It uses the language shall not be questioned about legislative actions, which suggests a reference to testimonial privilege. And so, we think the textual support for legislative privilege is actually stronger than legislative immunity. So legislative privilege should be construed in Tennessee to be at least as broad as legislative immunity. And that is the reasoning adopted in one of the cases that we filed this morning, which is—
I have not read anything that you—
I was going to say the same thing.
Please recognize that.
Yes, Your Honor, of course. I'm just directing your attention to it now.
That's why we imposed a deadline by which materials were to be submitted to afford the panel the opportunity to review that prior to today.
Yes, Your Honor. Respectively, plaintiffs made 2 arguments about privilege in their supplemental pleading that they could have made in their opening motion and did not. Instead of citing a case to you without having submitted it to the court, we made the decision to file a supplemental authority so that on the off chance you had the chance to review it, it would be submitted. But I understand that the court may not have had the chance to look at that. But I would direct the court's attention to that case. The 3-judge panel in Moses versus Goins did adopt the reasoning that we have advocated here. It relied on Hubbard to do that. My friend on the other side said that Hubbard had applied a balancing test. In fact, Hubbard rejected a balancing test, and it said that legislative privilege was essentially absolute, consistent with Tennessee legislative immunity precedent, if the documents sought related to legislative acts or legislative motivations. And in answering one of your questions, Chancellor Moskal, my friend made clear that they are interested in legislative intent. My friend said, is ambiguity, they're searching for whether ambiguity is a feature, not a bug. So plaintiffs are clearly interested in legislative intent, legislative motivations, and that's exactly the type of information that is at the heart of the legislative privilege, what went into formulating, proposing, and adopting legislation. And that's also clear from their specific requests to the General Assembly and the Governor's Office. So if you look at request numbers 1, 2, 3, 4, 9, and 11, they all quite clearly relate to that core legislative function of proposing, formulating, adopting legislation. For example, number 2 asks for all documents and communications related to any actual or proposed statutory exception or affirmative defense to the so-called abortion bans. Number 3 requests all documents and communications related to any enacted or proposed amendments to the so-called abortion bans. And number 9 requests all documents and communications related to the legislative history, purpose, or intent of the medical necessity exception. all of that falls well into the heartland of legislative privilege. And their requests, the remaining requests, appear to ask for documents and communications that the General Assembly or governor would have been aware of or might have considered in formulating legislation. I think that inference is consistent with my friend's representation today, that they are interested in these documents so that they can test the interests of the General Assembly in adopting the challenged abortion statute. And again, federal courts consistently hold that that sort of information is covered by legislative privilege because it's part and parcel of the legislative process. And federal courts also hold that to the extent a governor is involved in that process, legislative privilege also covers his documents and communications. And, you know, to the extent that plaintiffs are requesting documents other than those, I don't think they have stated the relevance of them. So we would just go back to our relevance objection. So it's really, you know, a two-part argument. If they're seeking information related to legislative acts or legislative motivations, those are covered by legislative privilege, whether they are in the General Assembly's possession or the governor's possession. If they are seeking documents other than those, then they are irrelevant, or they are of such minimal relevance that given the burden of searching for them, it would be an undue burden to ask the General Assembly or the governor's office to go searching for them. I won't touch on deliberative process privilege unless your honors have any questions about that. Okay.
I do not, but that's up to you whether you want to address it or not.
I'll just rest on the briefs with respect to that. I think we think that legislative privilege covers all of the relevant documents here, but we have asserted deliberative process privilege in order to preserve it. I think it's quite clear under Tennessee law. In fact, Swift said there was no doubt that it applies to governors in meetings with staff or cabinet members. So we do think that that would cover many of the documents of any relevance sought here.
So just to make sure that I understand where the state defendants are at, or the non-party subpoenaed entities and governor, none of the Tennessee legislative bodies has conducted a search. So you don't have a group of documents that are withheld.
That's correct.
Nevertheless, you're asserting a privilege as a basis not to have to conduct the search. Do I understand your position correctly?
That's correct, Your Honor.
All right. And with respect to the governor's office, the governor has conducted at least some search, and you have withheld documents from the responsive documents that were identified. Have you provided a privilege log with respect to that group of documents?
No, Your Honor, because we're asserting that it would be an undue burden even to run search terms on those documents, so we haven't reviewed them.
So again, you're asserting a blanket privilege so that you don't have to either search for or respond or produce a privilege log.
Yes, that's correct.
In a nutshell, if I have
yes, that's
captured
correct.
that.
That's correct. And as I said, we think that the court doesn't even need to address the privilege argument if it agrees with us about undue burden. But yes, Your Honor, you have summarized our privilege argument correctly. I want to touch very quickly on plaintiffs' waiver arguments, which, as I said, they raised for the first time in their supplemental pleading, although they did not explain why they couldn't have raised it in their motion to compel. So plaintiffs advanced two potential waiver arguments. One is the failure to provide a privilege log. As we explained in our opposition brief, we believe given that legislative privilege bars any sort of discovery of legislative documents, that there's no need to provide a privilege log. And that is consistent with Hubbard. That reasoning was adopted in the 3-judge panel opinion I mentioned. And in that case, plaintiffs did make the argument that plaintiffs are making here, that in order to evaluate legislative privilege, the Office of Legal Services needed to provide a privilege log. And the court rejected that argument, adopting Hubbard's reasoning.
Is that the Moses case you referred to earlier?
Yes, Your Honor.
What's the citation for that?
We included it in our supplemental filing. It's just an order on the docket.
It's a trial court decision, correct?
Yeah.
So it is not
Okay.
binding precedent on this panel. It is a sister 3-judge panel.
So
That's
it wasn't even adopted and approved by the Court of Appeals.
No, Your Honor.
Affirmed. Sorry.
Yes, that's right.
Okay.
And I can give you the case number if you would like.
Yes, I would.
It's case number capital C, capital T as in Tony, -1579-19. And the order was issued on June 24th, 2024. But as I said, we did enclose that in our supplemental filing, and we'd be happy to resubmit that if that would be helpful. One last point on the question of whether failing to produce a privilege log waives the privilege. We disagree with my friend's history of the state's assertion of privilege. We objected based on privilege and other grounds in mid-April. We told plaintiffs at a meet and confer in July that we had not done any searches for either the governor or the General Assembly and would not be doing so. More recently, we told plaintiffs we would consider submitting a categorical log on behalf of the governor, but never said we would. And once the governor did the undue burden search, realized that it would be an undue burden even to run the search terms. Plaintiffs also argue that the governor waived privilege as to communications between members of the governor's staff and legislators by producing such documents in response to a public records request. There are a number of arguments against that position. For one, plaintiffs don't cite any authority for that waiver rule, and the authority that we were able to find provides that the rule is that legislative privilege as to certain documents is waived when the legislator publicly reveals those documents. So it's not some sort of blanket rule where if you waive privilege as to one document, you waive privilege as to all of the documents in that category. That would be quite the breathtaking rule. That's not the case. Second, for any communications with legislators, which are precisely the documents plaintiffs say the governor's office has waived privilege for, any legislator would also hold a legislative privilege with respect to that document, and the governor can't waive a privilege held by another person. And the General Assembly is stridently asserting legislative privilege over any communications with the governor that would be would relate to legislative acts or legislative motivations, which are the documents plaintiffs seek.
Did you certify in your responses to discovery that with regard to the documents that the governor's office produced, that the governor's office did in fact produce all documents that had been made publicly available pursuant to public records requests on these topics?
I believe so, Your Honor. My colleague, Mr. Griffin, may be able to answer that more precisely. I don't know if he wants to jump in.
Good afternoon, Your Honor. Stephen Griffin here for the Attorney General's office. We did attach an objections letter from the governor's office to the declaration of Rob Mitchell, which was attached to our response in opposition to the motion to compel. But Your Honor, my understanding is that all public records requests responses from the governor's office that pertained in any way to the issue of abortion were produced to the other side.
And my question was, did you provide that in form of, any kind of verification? Or were they just included within the documents that were produced from the governor's office?
A verification that these were, in fact, all of the
That these
documents
were,
that have been.
that these were all of the documents that on those topics that had been made publicly available pursuant to a Tennessee Public Records Act request.
I don't
That's a
believe that.
that's a pretty precise question, and my guess is that that type of verification was not made, that these were just included within the documents because they had, as a matter of fact, been made publicly available.
That's right, Your Honor, and it was addressed in the declaration of Rob Mitchell from the governor's office that we've attached with our response in opposition to the motion.
We'll take a look at that. Thank you.
Your Honors, if you don't have any more questions on privilege, I'll move very quickly to the question of whether the state of Tennessee can be deposed.
I'll turn to my panel members to see if you have any questions on any of the privileges.
I have no questions.
None from me.
All right, you can move on.
Okay, thank you, Your Honors. So we argue the state of Tennessee cannot be deposed. The state is not a, quote, public or private corporation. It's not a partnership. It's not an association, and it's not a governmental agency. Under the text of the rule, that means it's not subject to deposition under Rule 30.026. And we, in our response, we pointed to both statutory and case law authority about why it makes sense that cities might be referred to as a governmental agency, unlike the state. They are political subdivisions. And we cited TCA 1323-1036, which actually defines governmental agency to include political subdivisions, which might include a municipality, but that definition doesn't include the state. Of course, that's not dispositive. It's just evidence of what governmental agency means. But we think it's pretty clear that it doesn't mean the state. Plaintiffs' cases are not on point. None of them appear to involve a situation where a court required the United States to designate a 30B6 rep. We think that's a very different situation when a party agrees to designate a representative merely for its own convenience than a situation where the court compels a party to designate a representative. None of those.
And did you find any case authority where a party was requesting to depose the state and the court held that it was not included within 30026?
Plaintiffs didn't cite any, Your Honor. Their one case, Pillow versus.
I was asking if you found any.
Your Honor, we didn't search much beyond the parameters of the cases that plaintiffs searched. We did search for case law using the term governmental agency and did not come across anything. I can't verify that. That doesn't mean something is out there, but
okay, thank you.
Oh yes, plaintiffs' foreign sovereign cases. There are 3 of those. 2 of them cite the third case, and none of them offer an analysis of what governmental agency means. They basically just say, we think a foreign state should qualify. So they're not very persuasive. And then the Tennessee case, Pillow, it's a very different case. All we have in the opinion is the opinion just says employee asserted that the state's designees agreed in their depositions about something. So there's evidence that the state has designated a representative in the past. Again, that doesn't mean that it's required to. And that was an employment case before the special workers compensation panel. So it's a very different situation for the state acting as an employer to designate a representative in an employment suit than for the state to designate a representative to speak on behalf of the state about the meaning of a statute and other related interests, when the Constitution and many other state authorities make quite clear that we have 3 independent branches of government and many independent agencies, all with different leaders in different positions. And for that reason, the state also isn't like a corporation that ultimately everyone is answering to the CEO. That's not what we have here. As perhaps illustrated by when the state filed the General Assembly's declaration, we have 3 different branches that act independently in the state. And then just briefly, I'll say about sovereign immunity. We argue sovereign immunity bars discovery against defendants. That's consistent with our motion for judgment on the pleadings arguments. And we think that it would also bar discovery against non-party state entities. And we've relied on Russell, which is a Fifth Circuit case, for that proposition. So we believe plaintiff's motion to compel should be denied on sovereign immunity grounds alone. And unless the panel has any questions about those issues, I'll turn it over to Mr. Griffin to address any remaining issues.
Thank you.
Your Honor, I just wanted to really briefly address the arguments pertaining to the production from the Department of Health in response to the plaintiff's third-party subpoena. There was a question about unpublished data on maternal mortality subsequent to 2022. The department published the latest maternal mortality and maternal morbidity data that it possesses just here recently in the last few months. And that data runs through 2022. It doesn't include data after that. It published its latest maternal mortality data in December. It published its latest maternal morbidity data in April after it received the plaintiff's third-party subpoena in March. Both of those reports are published on the department's website if the court would like to review those. They're easily accessible. And the way the department does that data collection is that they collect medical records related to any
Did you
adverse...
provide those reports to the plaintiffs?
Yes, those reports have been provided.
Okay.
And in fact,
that's what I need to know.
Your Honor, we produced more maternal mortality data going all the way back to 2017. And so we produced...
Now my next question is, and excuse me for interrupting, my next question is, what about the unpublished data?
Well, Your Honor, that was my next point, is that there is no unpublished data to produce. The way that the department gathers and produces this data is that when an adverse event is reported to the Office of Vital Records, department personnel will then proceed to gather medical records and analyze medical records, gather other information related to those adverse events. It will then proceed to put together data that reflects the information that they have found in medical records from those adverse events, and they will publish it in a report. So as of today, there is no other data to produce. It doesn't exist. And so the latest data that the department has already been produced in this case. The court's obviously aware that the rules do not require a party to generate information or to create new documents in response to a discovery request. And so
what I'm trying, and I probably didn't ask it correctly, but what I'm trying to discern, you've got published reports. You've produced the published report. You have data subsequent to those published reports. I'm assuming you've gotten, the Department of Health has some data since 2022 in its possession. And I don't know what form that's kept in, even though it hasn't been placed into a publishable report. It does have some statistics or information in its possession post 2022, I assume, but help me if I'm incorrect in that assumption.
Your Honor, the way that they collect and produce this data is that the report that comes out it has a 2-year lag time. And so the report that came out in December 2024 with maternal mortality statistics reflected data collected from a review of medical records from 2022 and before that. And so
I understand in terms of your publishing the reports, but post 2022, what data does the Department of Health collect and have in its possession?
my understanding is it would be in the process of collecting medical records related to adverse events reported to the department from 2023. And so it may have medical records, but the plaintiffs asked for maternal mortality data. There is no collected presentable data on maternal mortality in Tennessee to produce. To the extent that there may be medical records that have been collected related to adverse events reported to the Office of Vital Statistics, I don't think they've adequately made a request for medical records pertaining to adverse events for pregnant women. We would certainly have objections to producing medical records if that's the request, but I don't believe that request has been made yet.
So just to be clear, I'm sorry to pursue this point. Adverse events have been reported. Does the department have any statistical sheet that lists the number of adverse events across the state that have been reported? We're not talking about producing medical records. Those have not been requested.
Right.
We're talking about data, and the number, a log, a number. And you may not know.
My understanding is that there is not data like that is available that's been put together. And so that if the court required the department to produce data like that, it would be having to go and create new documents that don't currently exist.
Go ahead.
Your Honor, the other issue that the plaintiffs raised in their motion to compel, it was not mentioned at all in my friend on the other side's opening argument, so I'm not sure if they're still pursuing it. On the motion to compel, point number 5, with the Department of Health, they also referenced unofficial guidance to physicians and healthcare professionals. It's unclear to me whether they're still pursuing that. If they are, I'm happy to address that with the court.
Well, I understood from your papers, and correct me if I'm wrong, and I may be, that there wasn't any responsive documents in that category. Am I wrong?
Your Honor, what the plaintiffs asked for was a super broad series of requests that asked for any guidance or interpretation of the medical necessity exception, things like that, implementation of the statute. And the department itself represented in discovery that it hasn't issued or endorsed any formal guidance to anyone, either internal or external, related to the abortion statute during the relevant time period.
That's what I understood from your brief, and is that the department's position?
It's the department's position that it has not issued or adopted any guidance to anyone related to the abortion statute. To the extent that the plaintiffs say, well, okay, the department itself hasn't issued any guidance, but what about informal efforts? We've told them we don't understand what you mean by informal efforts, to the extent that they're asking us to search the files of the 3,000 people who work at the Department of Health to see if there's some random person who made a comment on email or in some file related to their thoughts on the abortion statute. We would say that, first of all, that is completely irrelevant to any claim that's been asserted in this case. A random statement by a Department of Health employee is not binding on the department. And we would also point out that the scope of that search would certainly be unduly burdensome and unreasonable due to cost. Your Honor, just already, and doing a—
Which request for production is this?
Your Honor, these are related, according to the plaintiff's motion, this pertains to request numbers 7, 9, and then 11 through 14. And for each of those requests, they asked about guidance provided by the department, and we made clear and we objected, but we also made clear that the department had not itself issued any formal guidance related to the interpretation or implementation of the statute. And so the
Subpoena
plaintiffs,
was addressed to the Tennessee Department of Health and
Right.
not to Tennessee Department of Health and all employees or staff personnel.
well, Your Honor, that's, part of our objection was to the definition of the Department of Health. And in the definition section, it included essentially everyone who is in any way possibly connected with the department, former and current. And so I would say that no, it was directed to everyone. And so we objected that request was obviously overbroad. It's unduly burdensome. We did conduct reasonable searches on behalf of the department that included multiple custodians.
I'm looking at the Department of Health subpoena and I'm looking at the definitions. And where is the Department of Health defined?
The very first definition, Your Honor, it says you, your, or yourself shall mean the Tennessee Department of Health, including each officer,
Thank you.
commissioner.
Thank you.
Yes, Your Honor.
I've got it. Please go ahead.
And so, Your Honor, we just have, to the extent that they're still arguing that informal efforts to provide guidance should be produced, our position is that request is unclear, it's vague. We're not sure what they mean by informal guidance, to the extent it means any random conversation by any person or any statement by any person who works for the department. That would obviously be
It doesn't
burdensome.
exactly say that. It says who performs a function on behalf of or at the direction of the department, or who is responsible for planning, directing, overseeing the department's activities. So it's not every employee within the department. That definition narrows it to persons who are in some position of responsibility. Am I reading that incorrectly?
Your Honor,
I do want to understand. I do want to understand what your objection and your position is. So help me out here.
Sure. And Your Honor, we made this objection to the plaintiffs. We made this objection to the plaintiffs 5 months ago. And during the past 5 months, we have never heard the plaintiffs give a narrow construction of that definition that Your Honor has just offered.
I'm just reading it right out. I'm just reading it right off the paper.
And Your Honor, the very last sentence of the definition says any other person acting in concert directly or indirectly with any of the foregoing.
And so you read that to mean every employee of the Department of Health.
That certainly seems like a reasonable reading of the definition.
I just want to make sure I understand your position. Thank
Yes,
you.
Your Honor.
Please go ahead.
And again, Your Honor, to the extent that they mean something else, we've made this objection, and they have not offered any attempt at all to narrow that definition or the scope of the potential custodians.
I understand.
We conducted a reasonable search of everyone we assumed would be likely to have responsive records. We spent dozens and dozens of hours of attorney time reviewing potentially responsive records for responsiveness and privilege. We ended up producing more than 1,200 pages of records that were responsive and not privileged in this case. The cost of hosting the data that we've searched is significant to the state so far. Your Honor, again, none of this information regarding informal guidance would have any relevance at all to the claims. And so, Your Honor, we would ask that the court, to the extent they're still pursuing that, would deny the motion to compel in that regard.
Right. Anything else?
Not unless the court has any further questions related to the department's production.
I do not. Thank you for your patience in answering them. Do you have any questions by my panel members?
I do not.
None from me.
All right. Thank you very much. General Adamson, does that conclude the state defendant's response to the motion to compel?
Yes, it does, Your Honor. Thank you very much.
All right, thank you. And I'll return to the plaintiffs. I noted that we finished with your argument right at the hour mark, but I had interrupted you quite a bit during your presentation, Ms. Goldstein. So with that grace, we're happy to hear from you in rebuttal.
Thank you, Your Honor, and I'll try to be as succinct as I can be. Just to go through the issues in some order. On the question of legislative privilege, Your Honor was quite correct to distinguish between legislative immunity and legislative privilege. Legislative privilege is clearly a qualified privilege, and that's illustrated in the Nashville case that I mentioned in my initial presentation, which was cited in our brief, which the defendants did not address in their brief and did not address in their presentation today. The Nashville.
And one thing that I will say, and I'll say again in this session, is please don't read anything into the questions. They are just directed at trying to make sure that the court understands what the parties' respective positions are. So I may ask them in a way that suggests something one way or the other, but please don't read anything into it. I'll give that disclaimer.
Understood, Your Honor. Thank you. But in any event, the Nashville decision, undertook the balancing that I referred to in my initial presentation in assessing whether information was subject to legislative privilege, and in fact directed that there be depositions of legislators in that case. The La Union case, La Union 2, which defendants rely upon in their papers, also undertook the balancing test, plainly showing that legislative privilege is a qualified privilege that can be overcome. And that just goes to documents that are covered by the privilege. There's also categories of documents and communications that are not covered by the privilege. And that would be many documents like the ones that we annexed to our supplemental submission, which were produced initially in response to a public records request. Our position is not that the production of those documents in response to a public records request is a waiver of legislative privilege. Our position is that those documents simply aren't covered by the legislative privilege. It may be that there are some communications between the governor's office and the legislature, which are so integral to the legislative process that they are covered by the legislative privilege. But clearly that privilege does not blanket cover all communications between the governor's office and the legislature. And so at a minimum, any such documents would not be covered by the legislative privilege or the deliberative process privilege and would have to be produced. And that's a key distinction, Your Honor, that some documents simply aren't reached by the privilege, and the fact that there have been no searches, no reviews, no privilege logs leaves us completely unable to determine whether documents are or are not covered by the various privileges, and if they are covered, whether that privilege should be overruled in the balancing act, and that will depend upon the relevance of the withheld document to the issues in this case. And that's something that we cannot know until we have a privilege log that describes the documents. So that is why that is so critical. One point that I wanted to make with respect to the long list of state interests that were made in connection with the enactment of 39-15-214. And that is that the statute that we are litigating, 39-15-213, supersedes 214. And that's set forth in 39-15-213, Section F. And Section F was added to the abortion law in 2023 as part of the 2023 amendment. And it's still part of the statute now. So to the extent the state wants to rely upon those state interests, they're not part of the legislative record of the statute that we're concerned with. And they're not pertinent to the medical necessity exception in this case, because it's superseded so long as Section 213 is in effect. That covers what I wanted to say about the privilege and the state interest. I wanted to add that just to correct something my friend said. We were never told in the July meet and confer meeting that the state was refusing to run searches for responsive documents. We were told that searches had not yet been run, and we suggested that it was appropriate that searches be run if the parties wished to litigate the issue of burden. And they certainly did not say that they were not going to do that. If they had, we certainly wouldn't have sent them search terms months later, and we certainly would not have waited to file the motion that we've now filed. In terms of whether unofficial guidance is relevant, it goes to a key issue in the case, which is, are our physicians confused? Are physicians reaching out to the Department of Health and asking for guidance, and is the Department of Health giving it? And so that's the reason that we think that anything that the Department of Health is advising doctors about with respect to the meaning or application of the abortion ban would be highly relevant to this case. On the 300206 depositions, there is no case holding that the state of Tennessee, or frankly any other state, is immune from designating a representative under 300206 or its federal counterpart, Federal Rule of Civil Procedure 30B6. And the argument that it's a burden on the state, frankly, makes no sense to me, because 30B6, 300206, is a device that is intended to make it easier for a party that is a large entity, such as the state of Tennessee, to appoint its representatives to speak on its behalf. Because the state of Tennessee is not immune from deposition notices. The alternative to serving a 300206 notice would be to serve dozens of notices to whoever we can think of seeking the deposition of the state of Tennessee by named official. And that would be much more burdensome for the state as well as for us. 30206 is a vehicle that was designed to avoid that kind of burden for parties in litigation. So we think not only does the rule plainly allow it, we think it's a salutary rule, and that the alternative would be much more onerous for the state. I guess finally, on the data that the Department of Health has regarding adverse events, I did not hear a clear statement that there are no tabulations in any form of the data that has been received in adverse events. It would frankly be surprising to me if there were no document in existence that tracked the number of adverse events received by the Department of Health and being reviewed by Department of Health employees. It strikes me as a matter of simple management that such things would be recorded and tabulated. And so we would ask that the Department of Health be directed to produce the data in whatever form it exists. And with that, Your Honor, I've run about 2 minutes longer than I thought I would, but I will conclude now.
All right. Thank you very much. Any questions from Chancellor Colbreth or Judge Donaghy?
No, thank you.
Thank you.
All right, very good. We've covered a lot of ground today, and I appreciate your patience in addressing the my questions, at least. Thank you for your briefs and your arguments here today. As I said at the outset, so that the panel can confer, it's necessary for us to take this under advisement, and we will get our decision out as quickly as we can. Thank you again for being present today and participating, and that concludes our hearing. We are adjourned.
Thank you.